This video discusses sensitive topics related to abuse. Listener discretion is advised.
That individual who was assaulted, that's the only evidence we need, and our system is broken because they always want more.
There are dangerous entities on a college campus for women.
You have to prepare for the potential of an acquittal and have done enough groundwork, have helped that child or that survivor enough that they don't see that as failure.
I'm Caroline Culbertson, and I'm here with 3 subject matter experts to unpack the themes of the PSA that we just watched. Elysse, many times victims can say that if they do choose to pursue justice, that the legal process can feel re-traumatizing for them after they've experienced sexual abuse. What about this process can be really challenging for victims?
We have to start from the premise of what our legal system is set up to protect, and that is the rights of the accused. So from the very outset of an investigation, you have the thought of, if this is going to go to trial, how are we going to overcome reasonable doubt? And that whole perspective characterizes a lot of how law enforcement and prosecutors like myself approach a case. And what that does is it really flips the narrative on its head and says all the attention is now on the victim, it proving what happened, what didn't happen, when it happened, where it happened, and why. And traditionally, prosecutors and law enforcement officers have been trained to ask questions of people, witnesses, victims, like they had just experienced a burglary or a larceny at a big box store. And what that does is it puts an investigative paradigm on a victim that is not reflective of the experience they had. So that turns out to look like you're not asking things in a trauma-informed manner. And when I say trauma-informed manner, what I mean is that we're approaching an investigation from the mindset of this person having experienced a trauma. And that brain, that trauma brain, looks very different from how our brains might be working sitting here right now, telling a narrative that sounds coherent, and we can say things from the beginning to the end when certain things happened and why. But when the legal system starts for someone who has experienced sexual assault, the questions of who, what, when, where, why don't work the same way as it would for us sitting here. So you're asking, when did this start? Why did it happen? Where did it happen? And oftentimes when a victim has experienced a trauma such as this, their brain is not encoding the details in the same way we would. And therefore, the recall of those memories is not going to look the same way. And we as a society expect someone to say something a certain way, and in these cases, they don't. And people who have not been trained to understand how to work within a trauma-informed system often will expect different things from the victim than they should. So questions will be asked not in a sensory manner. When you think about someone who is experiencing a trauma, things shut off to that linear narrative. They're thinking, what am I hearing? What am I seeing? What am I feeling? Because it's a survival mechanism. And so then when you're asking them questions in a trauma-informed way, you should be asking, what were you feeling? What were you seeing? What were you smelling? Because that's how the memories are encoded. But then when you're asking questions in a traditional way, it's automatically, well, you must not be telling the truth. You must not be telling the truth. Oh, and that coupled with there's no physical evidence left. And oh, by the way, we're asking you these questions, and then we're expecting you to go to the hospital, and we're going to do a very invasive PERT kit, physical evidence recovery kit, which is colloquially known as a rape kit. And oftentimes there's no physical evidence left. And so then the question still becomes, well, if there is physical evidence, is it from consent? So did you consent to this? Did you want it? Did you give the wrong signals? So the narrative is flipped onto asking questions of the victim and having expectations that are not realistic and don't actually match what the science says.
Anything to add on to that? Because that was very powerful.
Yeah, it changes slightly when you get out of the criminal system in which you operate. So when we're getting that survivor, they may have come through that process and been in a not trauma-informed environment, be questioned by police officers multiple times in and out of the hospital. And they're not necessarily encountering someone who's being retained to be their advocate. and to be very focused on not re-traumatizing them, and very focused on maybe certain specific pieces of evidence that are uncontrovertible, that we know a defendant, maybe not by a reasonable doubt, but a defendant is never going to be able to reasonably explain. And that singular piece of evidence may give enough leverage to get that person the justice that they're seeking. And so it's very different, and it's empowering in different ways because they're working with a partner and someone who's representing them and their interests in getting justice. And that's not always the case when the perspective is, well, can we prove this beyond a reasonable doubt? You're not technically their lawyer.
Correct.
And so we often are dealing with survivors after they've not had a great experience in the criminal system, and they come to us for real justice out of the civil system.
And out of the criminal system is broken. People are not trauma-informed. Judges are not trauma-informed. I have made it my life's mission to be trauma-informed because of the kind of practice I had and just a lot of different things. But a lot of people are not trauma-informed. So the first time they talk to a victim, they're shutting that victim down. Those memories are going forever inside them until they're unlocked, maybe in a few months, maybe in a few years, maybe never, maybe in 60 years. But when you ask, why were you there? Why were you wearing that? I tend to tell people to not ask the why questions because why tends to shame and blame. You have to ask those open-ended questions. You know, how are you feeling? How did this person make you feel when? Or whatever it is. So take the why out of it. Because when you start shutting people down, it is, whether it's civil or criminal, it's really hard to get the evidence you need to convince a jury or go way backward, law enforcement, prosecutors. And the other thing that shuts a victim down is a victim can be raped dozens of times. And prosecutors charge 1 or 2 because they know that's winnable when they should charge the dozen times that that person was assaulted. So in that way, that person is not felt to be heard. They don't feel they matter, and they wonder, well, what happened to those other 10 times? Why are they choosing only these 2? What's wrong with me? And we have to stop having victims feel like, what's wrong with me? Why am I being blamed? And get rid of all of that. Yeah. So trauma-informed people should be involved. They aren't always, and they shut victims down.
Yeah.
And asking and opening up that dialogue with the victim. I mean, from the very fundamentals, we think of victim versus survivor. So language matters. And in the criminal justice system, we use victim because that's what's in the code. That's what the jury instructions say. And it's not meant to be a pejorative, but it can sound like a pejorative. So I always try to open up that dialogue and explain that to a victim when they come in to meet with me for the first time, that this is not, I don't want you to adopt this label as an identity. It is a stand-in for something. And I want to empower you to define how you want to be seen, how you want to be felt. And sometimes that is, I identify with the term victim. Sometimes that's, I identify with the term survivor. But from the ground level, to be trauma-informed, it's about having that dialogue, explaining maybe this charge is stronger than the other. So I don't want to put that one on because it's going to cause these questions to be asked or open a certain door to a type of questioning. And a victim comes into the criminal justice system not knowing that, not understanding that. And these decisions are made behind closed doors in a way that removes their agency when we can actually look at it as an opportunity to give them agency.
Yeah.
And I would say that one of the things that's missing from all of the dialogue is when a survivor or a victim comes into the legal system, maybe starting with the criminal system, your office may be focusing on the perpetrator, whereas there may be a whole set of circumstances that had this person put in this position, or had this person set up to have this happen, or had a dangerous environment that resulted in this. And so often when we're dealing with survivors or victims, that's never been looked at by the criminal system. So the structure that was involved in being a cause of this trauma is being looked at for the first time in depth in the civil side of things.
One of the things that strikes me, and I've learned a little bit from having these conversations too, is particularly if this happens to a young person, this is such an adult environment for a young person to have to experience. And there's even terms that even law enforcement might use in trying to understand kind of what the situation was here that young people and children do not even know,
Yes.
don't even understand. That in and of itself must add to the trauma of this.
Does, and it also gives opportunities for centers like children's advocacy centers, which are integral partners for the criminal justice system. I could not do my job if I didn't work with a CAC. And what a CAC is it's a center designed to have wraparound community services, including therapy, family support, and most importantly, forensic interviewing. You don't want police officers who haven't been trained coming in and asking these kids these questions. You want people who know how to talk to kids, who know how to ask questions in a non-traumatizing and non-leading manner so it's defensible. So I can bring this video in and show it to a judge and have there not be questions about like, oh, well, the police officer was telling you to say this. And these kids are so impressionable. It's all on video. And then they don't have to say it over and over and over again to multiple people.
Yeah.
So it's important to have those partners on the ground level who know how to work with kids and understand how kids experience trauma.
And that really works in trial. And then they use dolls and drawings and all of that, which also helps the child not have to say it because they don't know the words, the terms. Or they've used the wrong terms because their family uses the wrong term. They don't say vagina, they call it something else.
Right.
And so it's important that we use the right terms in all our families, vagina, penis, breast, and be comfortable saying that. But so many people are not. So those diagrams really help, and they do a great job with that.
And I would say that, yeah, it starts certainly with children not knowing about the system, not just words. They know nothing about that system that they're going to enter, but that's also true of most adults that
Absolutely.
encounter this. You're a 32-year-old person. What in your life have you done that would have given you an idea as to what's going to happen if you enter the criminal justice system as a survivor or a victim? Same thing on the civil side. It's all news to them, and again, that's sort of one of the differences where between maybe the criminal side and the civil side is that when they're in our field, we're their lawyer. We're not the system's lawyer. And so even when we're talking about trauma-informed or titles like victim or survivor, we often don't put either of those labels on the person we're talking to. It's just Jane or John Doe or Jane Doe or whatever her name is. It's just very different. And it's very empowering because for them, they actually have an advocate that's theirs, not someone else's advocate that's stepping in to do one part of something.
Or having to explain, I'm the prosecutor, so technically my client is the Commonwealth of Virginia.
Exactly.
And that is such a hard distinction for people to understand, and something that a lot of times breaks my heart to have to explain because they want to call me their lawyer.
Yeah.
And from a systemic perspective, I'm not, and that's why we try to also have victim advocates in our offices, and they're mandated by law in many places, Victims' Rights Acts. So we have an independent victim witness coordinator in my office who works directly with victims, whether they're adults or children, to advocate for them in the system, support them in the system, connect them with resources.
What does that look like in practical terms? Like, what does that advocacy actually look like in kind of a day-to-day basis?
So that's a great question. And I like to tell everyone I couldn't do my job without my victim witness coordinator. She and I work very closely together. Our offices are right next to each other. I have a therapy dog that I work with children with, that I trained. That was actually part of the reason I wanted to become a prosecutor, so that I could bring a dog to work with kids. And so she and I work together in meeting with victims and kids in a soft interview room. So she has couches and toys and like refreshments. So we're not meeting with people in the police department or in my office with diplomas on the walls. And we're meeting in a comfortable environment where then I can have this victim witness coordinator be in constant contact. If this person needs to to have a question answered at 2 o'clock in the morning, my victim witness coordinator is answering that. If someone has to go to the hospital for a SANE exam, a sexual assault nurse examination exam after an assault, my victim witness coordinator is there on the ground, hand in hand with police officers, always doing whatever she can to connect them with therapy, with the finances to pay for therapy through victims' compensation funds, which are available through state governments. She's on the ground working with me all day, every day.
Yeah, that's such a great point, and something that I hadn't even talked about. And we were talking about, the adult language of this process, but also the physical environment, the way that these rooms look. I mean, when we're talking about children, if you walk into a third grade classroom, it certainly is not just beige walls with diplomas and encyclopedias everywhere. There's a certain feel to it that makes kids feel like this room is for them. And I'm wondering if there are any sort of measures that you have observed that can make people feel a little bit more comfortable, especially if they're that younger demographic.
Especially if you have a younger person, but really any age. Prosecutors bring them to me, usually in a lunch hour when the court's closed. And I walk in with my robe, and especially the younger the child, the better. They'll sit in the witness chair so that they get the feel of it. And I will say, I need you to think of me not as this scary person, because I look scary in this black robe, but I'll unzip it and I'll show them, because I'm not your typical judge. I wear jeans and a shirt to work often.
Love that.
Casual clothes because I'm sweating, dying on the heat on that. But I show them, I unzip it and I say, look, they make me wear this ugly robe, but I'm just like, your mom or your grandma or your favorite teacher or what have you. And I try to take scary out of it. We have squeezy balls, we have some fidget things and other things to make them comfortable. The dog is tremendous. But walking around the courtroom, having them own a little piece of it, regardless of the age of the victim, owning the space that they're in is really huge in how comfortable they are. And it's very, very important, really, for any age. And you were talking about how victims feel, and adults. So many people with children often get blamed, but more often than not, it's, the child didn't have control, they shouldn't have known, they didn't know, all those things. But with adults, so many of them come in front of me, and when they give their victim impact statement, I should have known better. I did something. And it's always, they put the blame on them. And it's really important for me with every victim that I talk to, because I talk to 100% of them. And I make sure they know you matter, you did nothing wrong, the blame lies solely on the perpetrator and all of that. And they need to hear that from someone in power, whether it's their lawyer, the prosecutor, the judge, because the system has brought them down, their families brought them down. It's divided families. It causes divorces and hatred and division. And so they bear not just the rape, the sexual assault, domestic violence, whatever's happened to them, usually it's multiple layers of things. They don't just bear that trauma, but it's the trauma of the division of their whole family, and the world they knew just blew up.
And a lot of those crimes take place within the context of a family. So you've got the courtroom divided on either side like a wedding, except the worst wedding you've ever been to, and the child is in the middle in the witness box. And so I always love working with judges who understand that dynamic and really want to be proactive about helping the child feel as comfortable as possible. And of course, judges have to be in that neutral role, and so you have to be mindful of that. But I think you just walk that, live that so beautifully. And as a prosecutor, I really appreciate that. You have to look at the statutes within your own jurisdiction. Can you do closed circuit television? So in Virginia, we can have another room where a child is being questioned by the prosecutor and the defense attorney, not in the middle of the courtroom. You have to have hearings to be allowed to do that, but that's a possibility. We have tender years statutes, which allow those forensic interviews that I described to be used in lieu of a child's live testimony in court, within certain restrictions to not violate the Confrontation Clause. And so you have to be creative and look for ways to help that child feel comfortable. I'll go into the courtroom and I'll have them sit in the witness box and I'll ask them pretend questions. And I do this with adults too,
Yes.
just to help them feel comfortable. Not specific questions about the case, but just let's feel comfortable in this idea of me asking you questions. I'm going to be standing here, the judge is going to be here, and just really making it understandable and helping them understand the reason for things.
Once there is a guilty finding and we're at sentencing, I make sure, especially with young victims, but with all victims, that part of restitution, because so many victims say, I don't want anything from him. I don't want anything. And they just can't stomach the whole thing. And in that moment, they're reliving all that trauma again and again. And they don't remember what happened in court. So I order in restitution the defendant to pay for a transcript of the trial, of the plea, of the sentencing, all of that, so that, and I give it to them sealed, so that they can, and if it's a child, it goes to the parent or the guardian, so that they can use that later in therapy to understand what happened, what was said, to remember that they were heard, that their attorney did a great job, that the prosecutor did a great job. And it really does help in their healing later on, because it doesn't end when we leave the courtroom.
Yeah.
And they're not in the courtroom for a lot of things. The victims they're entitled to, many states are entitled to be present by code, by statute, but oftentimes they choose not to. And that's another thing that you want to give them the choice, the agency to make that call. And so I think it's beautiful that you give them the opportunity to revisit that should they want to, and in the context that they want to down the road. It's so empowering.
And we very rarely have our survivors in court for a full trial at all. It's usually reserved for the very end of the plaintiff's case, where they make a brief appearance if that's necessary, give a brief bit of testimony, and they're fully prepared to deal with defense counsel. And usually then it blows up from there, because you have to be an outstanding defense trial attorney in order to question a survivor in a way that just does not enrage people. But you're talking about the systems that are destroyed within the family. So much of this violence takes place in a school setting or in a different institutional setting. And so if that happens for the young person in a school setting, you know, we think about it, all of us are educated, we went to high school, we went to college and all those sorts of things, and we have memories about high school and things like that. Well, this destroys much of that for a lot of these kids. You know, in college sexual assault cases, what does the college athlete then think about the college and where they were recruited to go and why they wanted to go there and where they put so much time and effort in when they were then sexually assaulted and maybe the university didn't stand behind them and was in that same blame game of like, how did you not recognize this was going to happen? Well, the trainer did it to you. Didn't you think to say no? And there's a lot of institutional betrayal that survivors experience. And it's something that we try to manage. The one thing I would say, though, in terms of the environment in which we question in the civil side survivors, is there's no protocol. There's no standard way of doing it. It's trying to first figure out who this person is and what's going to work for them without re-traumatizing. Is it going to be with their family present? Is it going to be in their house? Is it going to be on video connections? How's it going to work for them? And even then, we absolutely shy away from putting them through a series of questions that they've already answered, perhaps in the criminal context. We don't need that. And we don't want to put them through it. If we were to ultimately need it, that may come later and that may be phrased like that. Well, this is something we really now have to talk about, but it's really an attempt not to re-traumatize them.
Doug, I wonder if you can give us a little bit of education for viewers who might not be familiar with, you know, the process of reporting that something has happened to you? Like, where does that begin? What are the steps that between making a report, whether that's to Safe Sport or to your college or to police, and then actually pursuing a case in court?
A civil case in court?
Sure.
Well, let's start with this idea, and I think you talked about it. It was a sort of the delay in reporting, and there's such a weird bias in our language that's used, which is like, well, then why did you delay in reporting? As if there's like a time frame that's supposed to be standard by some measure. Why did you delay a week in telling anybody? There's no delay anywhere. And for everyone, it's different. So there's a lot of different ways to report, and some of them are more important in different ways. Like, so if you talk about reporting to Safe Sport, you may not get some of the same remedies from doing that, but you may help Safe Sport understand that there are complaints against this particular coach or this particular participant in the sports world. And regardless of where that goes, at least there's some notice being given to a regulatory body so that this individual may not continue to be a coach somewhere else, or, you know, things of that nature. Like, so for instance, in college athletics, you know, trainers can lose their licensure if they report it to the state and there's an investigation by the state so that they're no longer licensed to practice. So some of those things matter in terms of protecting others. In the civil side, we often have people, survivors, victims that are coming to us that did not make a criminal complaint because they didn't necessarily want to face that sort of re-traumatization and perhaps fight that battle to hold that person, get that person to be held criminally responsible. But they're looking at it from a perspective of, well, this is how it's damaged me and adversely affected everything in my life. And I think there should be a remedy for that. And it may not just be against the perpetrator, but it may be against the system that was involved in having that happen. And that system may actually be responsible for compensating that person for the harm they suffered, which is not in the criminal process. So where the judge was involved in the Larry Nassar situation, that involved the criminal prosecution of Larry Nassar. What it did not involve was, and this is no fault, it's just the way the system works, it did not involve compensation and claims against, you know, the organizations, USA Gymnastics, Michigan State University, to compensate these athletes for the harm that they suffered. Both were important remedies. You had, what, over 100 witnesses in your court?
I listened to 169. Overall, about 505 plus were found. In the long scheme of things between the civil and the criminal, there's 505 plus victims.
Yeah, and those were the victims coming in to have agency and a chance to face that perpetrator. What it didn't involve was the agency of facing USA Gymnastics and Michigan State and other entities and saying, and how could this have gone on? What were you doing that could have protected me? Why were you asleep at the switch? Why did you permit this to happen? Why did you work elbow to elbow with Larry Nassar and allow him to do, you know, pelvic examinations and things like that? Where were you to have stopped this? Or where was the protocol? Where was the training? And so that's a big focus of the civil litigation, to enable a survivor to look at those types of things. And if you think about it, if you're on your average college campus, there are dangerous entities on a college campus for women. I have 2 daughters, and I told them about going into fraternity houses. Because in so many circumstances, in order to perpetrate a sexual assault, you need to disable somebody and cordon them off from others. So you need to have some sort of private space and disable them. And fraternity houses on college campuses are one of the primary locations to do that. Fully unregulated, poorly managed. They've had a history of sexual violence in there for decades. And this gives an opportunity sometimes for people to hold them responsible and maybe to initiate change and change in protocols.
Yeah.
And bringing up safe sport, I think, is important, especially when you think of other types of outside the judicial system remedies for things like this that have happened, because there's such a pushback in some of those places, especially safe sport, and saying, well, why are you using this system? Why not just go to the criminal justice system? If it really happened, like, why are you doing this? Why do we even need this? And people don't understand in their silos, if you're in the athletic context or the educational context, and you've never been in the criminal justice context, you assume, or people might assume, that it's a lot easier than it actually is, because all their exposure is Law and Order SVU. So they're sitting and saying, well, safe sport is unfair and safe sport does this. And I'm not saying that there are not aspects of it that need to be fixed, but the reality is that we need more than one way to get to an answer of justice as defined by that person. So it's really important to have that explanation for why the criminal justice system, just because it wasn't beyond a reasonable doubt, didn't mean it didn't happen, and doesn't mean there shouldn't be consequences.
And in the case of Larry Nassar and many of these predators and the universities, the sports, the Olympics, it's money and medals over the safety of children. They are simply property. They are not human beings, and however you treat them is fine. Let's just get to the winning line, and let's get to the money and the notoriety and the medals. And they didn't care about the rest. They didn't listen. Larry Nassar is like every other predator I have in front of me, and that's where, he gaslighted them, and everybody around him gaslighted when they said, he's doing something wrong to me. No, it's medical protocol. He's fine. But if you do this, then, the program will close. He won't be here. You won't get to the finish line. So they would say, well, basically, we'll ghost you. And then Larry would groom them, as predators do. I'm the only one who can get you to the finish line, or I'm the only one who loves you, or any of those things that they groom you to believe. And so that you are complicit in, you take your pants off, you say, okay. And that's the way it should be. I have no power. And then Nassar, as many predators do, gave gifts, saying, this is what will happen. I was there. I'm going to bring you there. And so you have to look for that gaslighting, grooming, ghosting, and gifting, because those, whether it's individual or collective, it is a common thread for all predators, whether we are putting them in the civil litigation or the criminal litigation. You can see all of those aspects, they show up.
Mm-hmm. I think a really common theme in this conversation has been institutional accountability. Mm-hmm. How in the world are institutions held accountable? What does that look like in a best case scenario?
In a best case scenario, you can accomplish at least two things for a survivor. Compensation for the harm that they've suffered, and the harm that they're going to continue to suffer, and then systemic change. And so in so many circumstances, when we've gone after institutions, colleges, clubs, high schools, part of what's always on the table are reforms. Is the school system going to do this? Are they going to do this? Are they going to do that, so that this would likely protect someone else from suffering the same harm? And I think if you do that for a survivor, it also does something to the defense, because most defense lawyers think that lawyers are just about money. Mm-hmm. And, like auto cases, what else are you going to do? You're just going to give somebody this kind of recovery, and that'll be the end of it. If you make it about change and protecting others, it empowers the survivor to think that this was just more than about themselves and more than just about money, but it was about protecting someone else. So they do have a legacy to move forward. But it tells the defense that you're dealing with someone different. It's not just going to be a common circumstance where you have to talk money. You have to talk reform. Mm-hmm. And that changes the dynamic of mediations. It changes the dynamics of the discussions with 65-year-old men on the other side who are typically, defending these cases, because it's not something they're familiar with doing.
Yeah. And you have to get rid of this thinking out there in the public that, oh, they got money, they're fine. They're not. There isn't a survivor who wouldn't give back every penny, every headline, everything that they got from this to get rid of the trauma so this never happened. If they could go back in history and erase it, they would give back everything and more. So this is not about them getting a big payday and people say, well, now you're fine. It doesn't work that way. They would all give it up gladly, and I've talked to thousands of them. They'd give it up gladly if it never happened, because they have to live their life like this. They don't know when they're going to be triggered. It alters their life forever. Rape, sexual assault is the murder of a person's soul.
And so then in the civil side, if you do have an opportunity to be talking to them about justice in the context of something other than just money,
Exactly.
change of some sort, impact of some sort, that affects them as well, because they'd give all the money back, but they also don't want to think, I just took all the money, all I did was take money, and now I should be fine. So it all is sort of sewn together.
And the monetary aspect of institutional liability is so important to consider as well, in terms of the influence that these institutions can have on the legal systems themselves. For example, you have entities like Boy Scouts of America or the Catholic Church, all very powerfully opposing statute of limitations reform, because they are going to have to face massive financial liability if the statutes of limitation are changed so that people who are in their 50s and 60s who were abused as children are suddenly able to go forward and make claims against these institutions. So when you're looking at holding them liable, you also are looking at some very, very powerful opposing forces to opening up the criminal justice system for monetary reasons especially. And so that's when you have the little guy, one person that's been assaulted, but their entire life has been changed, and you're up against an institution. It requires people like Doug to be able to collect survivors, collect victims, to have an impact to push back against those large entities that are difficult to face one-off.
And sadly, the only thing they understand is the dollar, the bottom line. So the only way to get them to change is to ask for those $1 million, millions and millions, billions of dollars, and hold them liable that way. Because otherwise, there's no accountability, and they won't change. And they take that coach and move them to the next university, that bus driver and move them to the next school. They don't care. So you have to make them care with the bottom line.
They declare bankruptcy.
Yeah, which is in part where the civil system comes in, because out of the criminal system, you're not going to get that system to be paying money. And you're right, like, so for the Boy Scouts or some of these organizations that have been involved in sexual assault suits, they fight the statute of limitations because it involves money, but they don't characterize it that way. They characterize it more like, well, you know, who knows what the proof would be from 35 years ago. Those officials are dead. There's no way to really defend these cases, meaning in some sense that the words or testimony of the survivor can't be challenged, so we can't consider that to be tested and now valid. And so it's characterized that way when it's really just about money.
My favorite excuse is, well, gosh, if we open up the statute of limitations, there are going to be so many people, we just can't keep track of it all. I'm like, okay, well, that proves the point. If there are going to be so many people coming forward, that's exactly why we need to change the statute of limitations.
Yeah, and if you think about those circumstances, so let's just take an example that would say it would be the Boy Scouts, okay? And from 40 years ago. You're talking about a young boy, 8 years old, in 1970, in that culture, who is sexually assaulted, and doing what? What does that 8-year-old know to do with any of that information? And were they even to figure out maybe they should say something to somebody? Really? You know, did it probably go somewhere? Or was it probably, Jimmy, you know, you may not have it right, or, you know, or they weren't believed.
He would never do that.
He would never do that. Do you realize he's
man.
an Eagle Scout? Yes, he's a Christian man. He, you know, would never do that. And so that was what they were fighting at the time. as kids, or not even knowing when they were kids, and sometimes not even knowing that that constituted sexual abuse.
Well, they don't understand. They don't have the sexual knowledge, the sexual context to understand that what is happening is bad. It's only once they're older, teenagers, young adults, that suddenly it aligns, it clicks. And this is not across the board, but all of a sudden you realize that these things that you thought were normal, with the retrospective lens of adulthood, you suddenly see them differently.
And the retrospective view from what we're even talking about now. So when we talk about trauma-informed or how to interview somebody, none of this existed in 1970 or 1965 or 1975. And so if you were a young person in that time frame, the idea of having a pathway towards reporting and being believed and not having the world come crashing down on you, that was just not realistic.
The other thing people need to understand is that 8-year-old boy that you're talking about, he is the evidence. And then it's a question of, is the testimony, is the circumstance, is the place he was there, is it credible or incredible? And people always want what they see on television, all the fireworks evidence. We don't always have that. But that individual who was assaulted, that's the only evidence we need. And our system is broken because they always want more.
Yeah, well, that gets to the old adage of like, well, this is just a he said, she said. And in the civil side, we often have survivors coming to us with that in their head. And we're almost always saying, that's just meaningless. You can be believed. We believe you. That is solid evidence. And okay, he may have it's usually he on the other side, he may have explanations for all of that, but you can be believed. And we can win with just that. And you can get justice with just that. So forget about some of those, he said, she said, or other sort of, not tongue-in-cheek, terrible tropes.
And that's why we have jury instructions that will specifically say, in these cases, the word of the victim is enough alone without corroboration. And that is because these crimes happen when there are only 2 people in a room. And if we said, oh, you can't prosecute, you can't hold someone civilly liable if we don't have corroboration in the form of a video or DNA, none of these crimes could be prosecuted. So we have, as a society and as a criminal justice system, a responsibility to think of corroboration more broadly and how we can line things up, like the room, the color of the room, how we can go back and look at the way, like you said earlier, furniture was arranged, or the time of day something happened, and you line these little things up and you create that corroboration that will enable you to obtain a verdict or a conviction. But you have to come from the perspective of there often are 2 people in the room, and that's how these crimes happen.
Yeah.
That's how they're allowed to happen, in the darkness.
And there's not always an injury, even in a fresh case. There might not be any tears, there might not be any blood, there might not be any semen or condom left. I mean, you just don't know, but the victim should be enough, and then we look at all those other factors. And the jury instructions do provide for that. And fortunately, attorneys who do this work will ask jurors, if I only present you with this, how would you rule? And then we get rid of those people who say, well, if there's nothing else, then nothing happened. So we have to be very careful in the system to get people who keep an open mind, who listen, and who understand that he said, she said, without consent is a crime.
Yeah, I think we have this idea in our heads, again, the Law and Order, SVU, sort of the Hollywood version of this, that there's always evidence, or there's always bruises, or there's always an injury. I'd love to understand from each of your perspectives how commonly that actually is coming into the picture, and then also how you navigate when there is no physical evidence.
I actually ask in voir dire, who here has seen Law & Order SVU? Can you put your preconceived notions about what a sexual assault investigation looks like? Can you put that aside and listen to the evidence and listen to the instructions the judge will give you? Because the reality is, we have forensic nurses come and testify in court to explain all of this in medical and scientific terms, but injuries are very, very rare. And no injury is consistent with sexual assault. Like you can come in and you can say that. It
doesn't look a certain way.
It doesn't look a certain way. And when you think about biology and the types of tissue that are involved, you're not going to see tearing often. Yeah. And especially with kids, if you're injuring a kid, they're not going to keep coming back. And they're immediately going to say something, and these predators don't want them saying anything. So they're oftentimes not causing injury on purpose. That's by design. And so you have to explain this to a jury with with professional expertise, the same as you would with a trauma expert.
Yeah, absolutely. How do you navigate this in court?
Well, I have to follow the law and I have to make those kind of rulings. But in terms of navigation, it's the lawyers do their thing. I make my rulings. The law needs to change on some things. That's my big take of all of it. I have victims, I have young girls who have babies. And their dad might plead, but they might only get a 2 or 3 or 4 year kind of punishment in prison by plea agreement because they say the child doesn't want to testify. My big question always is because when I talk to them, they do talk to me, and I say, I don't have to accept this deal. We can go to trial. And sometimes they say, okay, but then quickly they'll change their mind. I've had a number of children say, what he did to me wasn't the worst. The worst was I had to give up my baby because my baby looked just like my dad. And the sad part is, why can't we have the DNA of that baby is what the dad has to face? Why does that child have to testify when the DNA in today's age is good enough? And we are re-victimizing people who shouldn't be re-victimized because our system is clearly broken. So navigate, I do my job, but I advocate for better changes because that's what we all need to do.
Yeah. Oof. Man, sorry, I gotta collect myself a little bit after that.
You okay?
Yeah. No, that's just the pregnancy hormones of that are really strong.
Yes.
Sorry. Can I get a tissue? I'm so sorry.
That brought you to tears, and after doing this for so many years, I mean, it's almost like it bounces off my head because of how much trauma that's involved in all of it. And you were talking about you wanted to go to an office where you could work with a trauma dog. Our office has multiple dogs in it on any given day, and it's not necessarily focused on who's going to be in the office in terms of a survivor. It's for the people who work on it.
I have the police department come up and hang out with my dog.
Yeah.
Just everyone who is exposed to it, it's so important to have that levity and that outlet and that grounding.
Yeah.
Yeah, we're in meetings and Stevie the dog runs in, and it affects everybody.
I have Clue the crime-fighting corgi.
Oh, that's perfect. Yeah. But I did want to say, in terms of that issue that we were talking about, that we're always looking for the real inconsistency on something. And often that's really helped if there was a police investigation. So if there was reporting and the police got to the technology, got to the computers, got to the cell phones, that's absolutely huge, especially in today's age, because so many people are communicating on those devices or taking photographs and things of that nature. And there's so much that cannot then be explained away based on the technology. But also other inconsistencies. So like, how was it even possible that that person came to know that person? How did they get there together? How did that young person have the cell phone number for a movie star?
Yeah.
It's impossible. How did they get it? Unless something was happening in a different kind of a way that can't be logically explained other than there was something wrong here. And so it's a little bit different necessarily sometimes in the criminal context, because we just may be looking for the one piece that drives an inconsistent response from a defendant that they can't, we call it immutable facts, something that's never going to change. You're never going to adequately explain this away. and it's leverage to get justice.
And that's the difference between beyond a reasonable doubt and preponderance, more
Preponderance.
likely than not. And so you might have a not guilty, but you might have a recovery. And so the two, you can't match the two
Yeah.
because they're very different.
Yeah, and I think that's where I'd like to hear all of your perspectives next. There's not one version of what success looks like for a victim, and winning is not the same as recovery. Doug, in the work that you do, what kind of impact has that had on victims, and what has winning meant to you for these victims?
Let's start off with, I don't even begin to put it in a perspective of what does their winning mean for me. I'm just doing my best. I'm doing the work that's necessary and to try to represent these people effectively. So my only perspective is what has it done for them?
For them, sure.
And one of the things that I just know it always does is that everything started with them being disabled and placed out of control and something horrible happening. And then from that pathway to where we're at, maybe a lot of other things happened as well that didn't give them agency or success or meaning. So maybe they went to the criminal system and it didn't work out. Or maybe they didn't go to the criminal system and there's doubt as to whether or not they should have, and people question, why didn't you do that? Maybe they didn't do safe sport, or maybe a lot happened on the way. But at this point, success might mean that at the end of the day, you stood up and said, hey, it's me.
Yeah.
You could add the phrase, motherfucker. And
I like that.
I am going to have power, and I'm going to change the way this story ends.
Yeah.
And I'm going to know now that I've done something, and I've stood up for myself, I've faced you down, and I will take that with me for the rest of my life. And I will know that on some level you might have had me down here, but I stood up. And I got up and made you have to respond to me, made you compensate me, made you go through your own personal hell with your family over what had happened or at the school or whatever's going on. But at some point in time, I was standing up and facing off with you.
Yeah.
And that's money, systemic changes, lots of other things. That is a personal thing that so many of these survivors take with them, regardless of age. So if you're 17 and you've had that experience, it also means like at 30, you've internalized that I'm not just your victim. I'm not just a person who may not, for whatever reasons, not be strong enough to face you off.
Yeah.
I am that person
Yeah.
that will protect myself and stand up when things aren't right.
Yeah.
And that's a message that lasts for a long time.
Absolutely. I know that reclamation of power by being heard is so central to your work.
Yes, I have always let every victim, regardless of the crime, speak. But especially when you look at domestic violence, sexual assault, it's very important that they are in court, they face their assailant, they face their predator, and say, I am mad and you hurt me and I'm taking my power back. Yeah. And I watch them grow 10 feet and they go from victim to survivor to thriver to someone who is an achiever. Because I don't like to stop them at thriver because they're not just thriving. They really start achieving things with their life and going farther than they were told they could go. Mm-hmm. They are going farther than they even thought they could go their whole life because now they've taken their life back. And it means the world to them. And I always try, because I think it's important to use the power of the robe. I have to do a lot of bad things with it. You're going to prison, you're going to jail, you're going to treatment, whatever. But for a victim, to turn them into that achiever, to take something that they have told me and to flip it back and say, you know, you will write that lullaby. You are a superhero because now you came forward and you spoke not just for you, but for all people who can't speak. You're an example. You are strong, you are whole, you are clean, all of those things, which I know people who love them have told them, but when it comes from the bench that I sit, we talk about rooms, I sit higher because that's supposed to be the most powerful point in the room, right? So from a position of power, when I tell them, you're up here with me and you're powerful, they take that and I see them literally grow 10 feet. It's huge. It really is huge. And I wish every judge did it. I've been told by other judges, Aquilina, now we can't do less than you. Why did you do that? How are you doing that? It takes too much time. And I've just said, retire and pour my coffee, because that isn't our job. This not my courtroom. It is the people's courtroom. They own it. They should be able to speak in it. They should be able to wrap around in it in the lunch hours and be comfortable and see where they're going. It's their courtroom. It's not mine. I just borrow it. I'm doing their work. So why can't they speak? Everybody affected by a crime. And why can't they tell me for as long as they want what happened? And without limit, we need to amend the Crime Victims' Rights Act to broaden the term victim to mean anyone affected by the crime. There's a lot of work we have to do. I could sit here for 2 hours and talk about legislation. I have taken to legislators. And do you think that they have codified any in law? Not many. It's not popular to talk about mental illness, sexual assault, and other things and to say, well, we got it wrong. Or they simply want to enjoy the prowess and not serve the public like they should.
Yeah, there's a big conversation too in the thinking about expanding the definition of victim in the gun violence world of everyone who is traumatized by gun violence, not just the person maybe who is physically actually affected.
And defining consent. It's not, in some states it is, but very few. And we need to define what is consent.
Yeah, absolutely.
For me, as much as you use that position of authority and power to empower the victim standing in front of you, behind closed doors, when I'm speaking with them, I actually get low. I get down to their level, sometimes below their level. And I have a real conversation with them about the fact that winning and losing is not necessarily justice. It cannot be defined as justice, especially when you're working in the criminal system, when it's beyond a reasonable doubt. And you have to prepare for the potential of an acquittal and have done enough groundwork, have helped that child or that survivor enough that they don't see that as failure. They don't see that as losing. And so I love this book called Truth and Repair. It's by Judith Herman. And she interviews survivors of sexual violence and over many years in many different contexts to ask them what their idea of justice is. And it's very different for everyone. Sometimes it's monetary. Sometimes it's, it's a conviction. Sometimes it is just taking your power back and saying, you didn't put me down. I am up here. I am going to continue with my life. I am going to tell my story. I am going to take my narrative back. And those are conversations that I really try to have at the very outset of the process, because the last thing I want to do is to compound the trauma by putting the expectation on them that they are solely responsible for getting this conviction. You want to empower them without putting everything at their feet and saying, like, I can't do this without you. I mean, the truth is that we can't prosecute crimes we don't know about. So I always have to acknowledge the strength that it took to come forward and say this happened to me, when there's such shameful things that have happened to people, but also saying that I am on this team. I am going to be doing a job. This is not just on you. I will be doing everything I can to help you tell your story in a way that is meaningful to you and that is helping you take that narrative back, regardless of the outcome, regardless of what the jury does. I want them to take that away as justice.
Yeah.
I love that you do that.
And the jury outcome, to harp on that point, is if you look at where it starts, where they've been placed out of control, and they're working to take the control back, they can't control that outcome. I mean, that's the 12 jurors sitting in some room. And so we try to separate that out, that you have controlled everything that you can control. You've done it, and you're successful here. What happens here, is again, not yours. Has nothing to do with you. It's 12 people that may come to some conclusion that's crazy, or it may be a crazy judge that rules on some motion.
Procedural issue.
Issue. That has nothing to do with the strength you've shown by getting here. And, you know, I mean, I think that's consistent with what you're saying, and that's something that we really focus on.
Yeah, one of the things I do when people don't have justice in the courtroom, civil, criminal, or the statute of limitations, so many people around the globe have reached out to me and said, I only want to tell you my story. And so they will actually travel to my courtroom. I lock the doors, I have my court reporter, and they stand as if they had their day. And they stand and they tell me their story. And then I do exactly what I do in every case, and I give them something back. And I say, we're going to have this transcript. I need you to have this so you can take it to your therapist. And in each case that's happened, they let me know, whether it's weeks or months later, I did take the transcript. I thought I'd remember it, but I didn't remember what I said. And I showed it to my therapist, and I told you more in those 20 minutes or half an hour, whatever it was, than I told my therapist in 5 years. And now my therapy's finally moving forward. I was stuck. But see, that's how important it is that they have their day, that they publicly say, I was hurt, I mean something, I mattered, I was stolen from, my body was stolen from me. And it's that important to speak and give them power.
Yeah. That aspect of being able to speak about your experience, I think, is something I want to talk about next. And I would love to talk about NDAs. And maybe we can just quickly define what an NDA is for people who might not know. And what do we see? What is the effect that we see on the victims and their families when that ability to talk about that experience goes away?
That would be great for
That
the
would be you. That's you.
That's me.
That's
Yeah,
you.
we can all talk about it, but you got the best experience here. Yeah.
Well, so let's start off with the premise that, you know, there's been some award-winning films about law firms that have pushed sexual assault survivors to execute NDAs. And it's a really controversial subject. And our firm feels particularly strong about making sure that the survivor is not silenced. You know, it used to be called catch and kill and stuff, and, you know, I'm not going to name names, but I've seen lots of NDAs around non-disclosure agreements. And historically, so you asked how they're defined, historically it meant in exchange for this settlement, in exchange for this result, you can't say anything. And there were small exceptions for you can talk to a therapist, you can talk to your immediate family members, provided, however, they don't disclose, they agree not to disclose anything to anybody else, and your tax attorneys or something like that. But what we've tried to do, because sometimes defendants are trying to buy the end of the road on this show that's maybe been in court or it's about to become very public, is to try to enable the survivor to maintain her voice and be able to write a book about something, talk to her friends about something, not take that away from her, but maybe eliminate being able to identify who the perpetrator was in this circumstance in exchange for the justice maybe that they've gotten. And we leave it up for them to decide. We push hard against, the typical defense counsel comes in and says, the doors will be locked on saying anything. And that's off the table from our perspective. Those are the old days. We didn't ask for that on behalf of our clients. And going forward, that's not part of what it's going to be.
And in that context, it's counter to public safety. We're not talking about an NDA over some fraud, like business dispute. We're talking about things that affect the safety of real people in the real world. And so it's even more, I think, important.
And oftentimes their own family, their own kids. We have to protect everybody.
Wow.
Yeah. And it's often, too, that the survivor wants absolute silence coming from the other side as well, for lots of different reasons. So maybe you're in your third year of college and you're trying to be a professional in the medical field, and you're involved in a potential lawsuit, maybe you've been identified as a Jane Doe in a lawsuit against your university and a coach, do you want your name out on the internet for perpetuity as someone who was sexually assaulted, someone who did engage in civil litigation, someone who did get a settlement? You know, there are a lot of people that think, well, that then defines me
Right.
to lots of people before I even walk in the door.
Yeah.
And they don't want to be defined that way. So we push hard on making sure that that's a piece of it, depending on if that's what the survivor wants. And I want to say this too, because I remember I was in a meeting of the National Crime Victim Bar Association, and an advocate who has done a lot of sexual assault cases against church entities, religious entities, said under no circumstance can you ever agree to a confidentiality agreement, an NDA. And I don't believe that to be the case either, because I represent this specific person.
Yeah.
And I'm going for what this specific person wants in their specific situation. And if in exchange for that, which they may not care about, some don't, some want this event gone and only on their own terms, talking to their therapist or talking to their family members, and they don't care about the rest. And if that's okay with them in the context of what they're getting in exchange, well, I'm representing that person. But I'm certainly going to advise them as to what the options are in that situation. And that's their decision. It's not my decision. So, you know, I got into a bit of a scrabble with someone who said there's just one rule on this. Right. There isn't just one rule.
Do you ever see that change over time? You know, somebody starts out thinking this would be the ideal outcome. This is kind of what I want from this process, and that changing over time as they go through the process?
Yeah, all the time.
What does that look like? And how do you support them through that?
I support them through that. You know, I'm engaged to give them all the strategies, all the available options, the pluses, the minuses, answer the questions, change my advice based upon something they may be saying to me about what they want to accomplish, and work in that setting to still come out and achieve the result that they've retained me to get, if I can. So, you know, it may involve some aspect of it that I hadn't thought about, for sure. That's great. Some aspect that I didn't think was going to make a big difference, but it makes a big difference to them, great. Something that I wouldn't normally do, but it works for them, great. It's really what our job is, a little bit different than yours.
And my job in that, I'm sorry, I didn't mean to interrupt you. My job in that is when they come and put a settlement in the record, most attorneys, and I know you do it, is to seal the amount that the person's getting, but not all attorneys are created equal. So there are a lot of attorneys who say, well, here's the settlement, put it on the record, and I have to make sure everybody's happy with it. Regardless of what the attorneys want, I seal it, because what ends up happening is people say, oh, this person has $500,000, $1.5 million, whatever it is, and now they are prey to other kinds of predators. So you have to think down the road, and as an attorney, I can't do this as a judge, but as an attorney, I would tell them, you know, in practice, make sure you have a prenuptial agreement, you have it in trust, you have it protected, because this is for your healing. And, you know, talk about those kinds of things. So people think, oh, you know, this happened to you, now you're wealthy. Well, no. And so there's lots of ways to protect them, because the other kind of predators come later.
Well, and not only just those predators that are looking to take the money or something, or manipulate the person in that way. So that's one of the reasons why it should be kept confidential. But it also helps eliminate some of those public perceptions of like, oh, okay, so she got her payday. Right. You know, this probably wasn't true, but she got her $2 million. And there's a dialogue about that that's connected to sexual violence and personal injuries in general, but heavily to sexual violence that we don't want to perpetuate. And candidly, most of the time that the money is allowed to be disclosed is because the attorney wants to
Get business.
get business and market himself or herself. And that's, that's just not doable in my world.
And when settlements get out there, like Michigan State, and I teach there, undergrad and at the law school, and what I heard from a lot of students was, well, damn, my tuition went up because they got that money in settlement. And that's a wrong perception. That's not why the tuition went up. It didn't go up any greater than it did any other year. I mean, the eggs have gone up, what, $4 or $5 a dozen?
Right.
So we have to get rid of the misconception that somehow a survivor is a winner here, because they're not.
Oh, well, and it's also that dialogue, too, was like, because it was a state institution, I've got to pay the tax, I've got to pay, my taxes are going to support sexual assault victims. How did that happen?
Right.
There's a lot of dialogue about sexual violence that, mostly generated by men.
Pretty out of touch.
That is out of touch with certain realities, and you don't want to perpetuate those myths or those prejudices.
If we partnered together, if we demanded our lawmakers work with us, actually talk to us, what do you need, and legislate and do their jobs, and we all partner together as a community, we don't have to have big payoffs. We don't have to have rapes. They'll go away. But right now, it's still behind closed doors. There's not enough discussion. There's not enough explanation. And we need to give schools latitude on teaching kids. It's their body parts. This is yes and no. You have a right to informed consent, whether it's with your doctor, your teacher, your parent, your boyfriend. My kids, when I say, great job, can I hug you? Even with my own kids, I don't just assume they're going to take a hug. You have to change what we're doing. My grandkids do not sit on Santa Claus' lap. Why? Not because Santa Claus is a bad guy, but because it gives this subliminal permission that it's okay to sit on a strange man's lap. It is not. So there's so many things we have to change if we simply partner together, acknowledge the problems, some accountability, and let's get the job done together. That's why these conversations are so important.
And
They are, but you're keeping hope alive, just like Jesse Jackson, because
I hope. I have to hope.
because so many of these dialogues are within a framework of men that control a lot of different systems,
Agreed.
legislatures, and are unduly focused on this concept of like, well, what about if I'm accused and I didn't do anything?
Right.
As if that's what drives the system. And those claims do not drive the system. I mean, all the research is that falsely accused are such a minimal statistic of what's actually going on, particularly when compared to what hasn't been reported. But that's who those systems are, in part
Right.
controlled by.
But even if we make it 1% better, it's 1% better.
Agreed.
And, when someone knocks on your door and says, vote for me, I'm going to say, I'm not giving you my money, my lawn. I want to know, what do you know about this? What are you going to do? What commitment are you going to make to me? And if they don't have the right answers, I'm waiting for the next person. And we all need to have that accountability before the sexual assault happens and start this, from the top down. Because where's their accountability? How many legislators have said, I'm taking it by the reins. I'm going to define consent. I'm going to get rid of the statute of limitations. I'm going to use the DNA of the baby that's born instead of the child having to testify. And there's so many basic things they could do, and they haven't even stepped up to the plate to talk to us about how do we get this done? What do you like to see? It's not in the legislative agenda.
And it requires, like you said, sort of a multidisciplinary approach. Multidisciplinary, but also multi-level. So someone like me, I'm in the trenches in a small jurisdiction in Virginia. Case after case, drop in the bucket, it feels like sometimes when you're seeing this all day, every day. So the way I mitigate that is by trying to do as much big picture work to counterbalance that as possible, which is why I'm on national nonprofit boards like Child USA for statute of limitations reform, because that I am very passionate about. We don't have statute of limitations for felonies in Virginia. thank God, but other places are not so fortunate. And so I try to leverage that ground level experience to help impress on people the necessity of this on a day-to-day basis. And so we can't do it if we don't have the people who are the big picture policy thinkers working in conjunction with the people who are the little guy in the trenches.
Well, let me give you right in your neighborhood, for example. After the Virginia Tech mass shooting, which was an issue of whether or not the students that were on campus had timely notice of what was going on campus so that they could take actions to protect themselves, there was an investigation that said students are adults and they're entitled to accurate, timely information. But like at University of Virginia, for example, and we've been fighting these issues for years against universities, there's so many sexual assaults that take place on campus, and in particular in the large Greek industry that's on every college campus. Why is it then that a university, if it's going to report sanctions that have taken place at a specific location involving a specific student group, they will not tell you that it was a sexual assault? So at UVA for years, it would just say, failure to abide by established risk management procedures resulting in harm. Well, behind that was likely a woman that was sexually assaulted. Should not other women know that on campus and that that's a location that's poorly managed and they need to stay away from? Or should they not know that so that if they're thinking about the Greek organizations, they can be like, well, what's going on with the sexual violence issue? Why aren't we told that this is happening? And that is part of the systems at most schools, most universities, is that people will stay in the dark. And it's again part of the systems that we change. When someone's sexually assaulted at a location, we've often gone to universities and said, well, here's how you're going to change your reporting system. You're not going to cover it up. You're going to say exactly what happened. And that's, again, working in different systems, not just at the government, but at university levels or at school levels.
And you did make a difference at UVA as a faculty member at the law school. I get those notifications now.
We did.
I honestly,
We did.
yes, so I just thought about that right now. Thank you.
Well, we did. And that's part of someone's legacy who knows about that, a family, a woman, and others. And that can't be taken away from them.
I'd like to talk about financial burden of pursuing a case. And then I'd also like to talk about kind of the unseen financial losses. You know, going back to this idea that, even if a settlement is reached, that a victim is not winning the way that we think that they're winning. So I'm thinking about, beyond just legal fees and all of the fees that are associated with a case for the victim and their family. There's also things like missing work, lost education, all of the bills that are associated with recovery, therapy, multiple therapeutic modalities. Sometimes there's medical bills. Maybe we can start to talk a little bit about that and kind of shape the picture of what the financial burden is of abuse.
Before we do that,
Absolutely.
I want to just add that what you're talking about, it's not like an illness that lasts for a year. When you're looking at trauma, we're looking at a lifetime of bills, a lifetime of counseling. It's a lifetime of triggers, and they don't know when it's going to happen. Some of them can't work. They have PTSD. There's all sorts of things that happen. In Michigan, sadly, and I just testified before the legislature to ask them to please not do this, they're putting a cap on damages of $1.5 million. And I said, most of you legislators have a retirement that's at least that. A victim is not going to have that kind of retirement because their money is going to their recovery.
Is it a cap on non-economic damages?
They're putting caps.
Okay.
It's not, yes. It's a little crazy, and I don't know how it was morphed into, but I went in and advocated that because in criminal, I can do restitution, which is for actual recovery. And in Michigan, we only allow one recovery, so I at least advocated if you must do this cap, which I totally say no cap on anything, and explain to them why, which is what we're talking about now, at least have it that the criminal and the civil are deemed one recovery. Because otherwise, what I order in actual restitution is reduced by what they receive in the civil side. So they're looking at reducing, and 1.5, I'm sorry, is not enough. And it depends case by case, because you don't know, but come on, it didn't happen to them, so they don't know.
And whatever the number is, it's arbitrary.
It is.
So when I first encountered this, I had a young man that was killed in a circumstance at the University of Colorado. And Colorado had as its public policy a cap on non-economic damages, which economic damages are the out-of-pocket things that you've been talking about. Well, I spent this much on that, I lost my tuition, I did this, we spent money on tuition, but he died, so we didn't get that back. The non-economic is the pain, suffering, the loss of consortium, all these sorts of things. And the cap was $240,000. So for a college student that was killed,
Oh my God.
and the parents' central damage was the loss of the child and everything that meant, it was $240,000. And we had 13 defendants that were involved in causing this death. And we went into mediation, they offered $10,000 because they thought the most they could be held responsible for collectively was some percentage of $240,000. And my client looked at me and said, I'm at a flea market over the death of my child.
Oh my gosh.
And that was a decision made by a legislature that was supposed, that's called tort reform,
Yes.
which is not applicable to every given situation. But it is something that we face. Like in Virginia, if you're going to sue Virginia Tech for the shootings, you're facing a cap of $100,000 against a public entity. Tell that to families where they believe that the school knew for an hour and a half about the presence of an active shooter on campus that they could not locate but didn't tell anybody, so that people left the comfort of their homes or their dorms, went out onto campus, and then were killed.
I was just down the road from it when it happened.
Yeah. Tell them that there's a $100,000 cap on that tragedy. Those are decisions made by legislative bodies under the guise of tort reform that a lot of attorneys are constantly fighting so that it's not in place. Because I will tell you, when it happens to the legislator's child or family that
change.
voted for that piece of legislation, they sit in our office and go, who thought of that?
Yep.
Like you, sir.
Yeah.
Though we don't say it that directly because they've been harmed, but that they see what it means, tort reform.
When I went in, I said, how much is your loved one worth? Because mine is worth, much more than $1.5 million. There's no price tag, right? But it hasn't happened to them. So it's not going to change unless one of them stands up and says, this is the reality because it happened to me.
Sorry, go ahead.
No, they just don't care about the rest of us until it becomes personal to them.
Within the criminal system, you mentioned restitution. I just wanted to make it clear what you're looking at for support in the criminal justice system. So I mentioned before victim witness coordinators. So I work with my victim witness coordinator in my office very closely. She is able to submit claims to the Virginia Victims Compensation Fund. And that basically is a fund that helps victims of crime defray costs associated with having been a victim of that crime. So we're talking about therapy, medical costs. It doesn't cover things like the, pain and suffering or the emotional distress. It doesn't cover like lost wages and stuff. So you're looking at that, or education, if you can't use the tuition for the rest of the semester. However, it does defray some of those day-to-day costs when you're talking about medical and therapy expenses, and you don't have to have had a conviction for it. So you just have to have cooperated with law enforcement, and that will entitle you to some assistance, which, don't get me wrong, is not nearly enough in the grand scheme of things. But if we're talking about, just walking in and using the criminal justice system and not doing a civil suit, that's the kind of financial support you'd be looking at.
And that's huge because it's there and it's meaningful. To give you an example on the civil side, though, we have a matter pending that involves someone who is sexually assaulted twice while seeking treatment for substance abuse. And the defense came in and said, well, in order for us to evaluate how she's been injured, give us her medical bills. And we were like, that's not the way this is going to start. Because if she's got $1,500 of medical bills related to that trauma, and she's still trying to hold her life together and still hold down a job, you're not going to figure out and evaluate the extent of her injuries based upon the medical records. That's often a thing that happens in, automobile accidents. Lawyers will say, well, 3 times the specials, 3 times the medical records is what insurance companies want to settle for. But in sexual violence cases, that trauma, as the judge says, it is with you for a long, well, I don't know when it stops necessarily. And when you get experts in the field to look ahead at what that survivor is facing, you find problems with families and relationships 20 years out. You find problems with jobs 20 years out. You find lots of different things that happen that are wholly unrelated to the medical bills or the out-of-pocket expenses, because those are often not substantial.
Yeah.
And there's things not thought of, like if a woman is sexually assaulted when she's younger, and now she gets married, she gets her life on track, she's pregnant. When she goes to deliver that baby and some man puts his hands in her, she blacks out. She freaks out. That's another huge trauma. There are traumas along the way. The other thing I want to say is, in terms of restitution on the criminal side, that is not forgivable in bankruptcy. But I'm not awarding thousands and thousands of dollars. They have to show actual receipts, and then there's a restitution hearing if the defendant disagrees and all of that. But, and you can talk about this, Doug, how many people file bankruptcy on the civil side? They're going to file bankruptcy if they can. So, there's a whole lot of problems with financial recovery and actually making sure people are covered timely, because like restitution, they pay when they can. A lot of times they're in prison, so how are they going to pay? They're making, $5 a day or less. So it's a financial burden on the families, and it goes on forever.
And that's where the compensation, the criminal injuries compensation funds,
but it's not everything.
Exactly. As much as you would like to extract the restitution to the compensation fund from the defendant sitting in prison, it's not going to happen.
And that is also, you're 100% right, because that's not often the circumstance that we're dealing with. So when the survivor comes to us for justice in the civil side of things, we have to evaluate for them, like at the end of all of this, are you perhaps going to get economically compensated for the harm that's been done to you? And so for the guy that's in prison and now penniless, or the guy that by the end of the day when he's done paying his lawyers to defend the case will not have anything, or the guy who's likely to file bankruptcy the minute this is filed and there's nothing going to be collectible from them, we have to talk to the survivor that this may not be something you want to go through. For all of this hassle at the end of the day, I cannot promise you that you're going to get something that lessens the burdens on you.
And that's something that I hear from people who are talking about going the civil route. They hear, well, there's not deep pockets on the other side. And that I know is a barrier to some people thinking that it's even worth pursuing, a civil suit, because if you're not going to get anything out of it in terms of money, there's not the incentive for players like some attorneys to take the cases. And so it's kind of it is a dual incentive there for the civil system, which is really unfortunate because we need both.
Well, and that's why both may not even be available to somebody, which is, just tragic. They may go into that criminal side, and you may not feel like you have, beyond a reasonable doubt, and they only have as potentially legally responsible under civil law, that perpetrator. And that may not be a viable path in terms of making any economic sense for them. And so they come out of both systems and they're standing alone with the trauma.
And I was just going to say, I know of a case, and it's sad. I think most insurance companies don't do this. They're dissuaded from doing this. But woman's raped, insurance covers what they can, medical insurance. She's raped again, which does happen. You can speak to that, both of you. And then the insurance company sees that second rape as a pre-existing condition based on the first one, and they refuse to cover it. Now, if that isn't wrong, and again, legislators have missed the boat. That should be in black letter law, can't do that, but that happens.
And when you're talking about the criminal and the civil both being foreclosed, then you're looking at things like, do we have a safe sport or a Title IX or something like that? And so that also speaks to the necessity for more options beyond the criminal and civil justice systems.
Yeah, though no secret that in Title IX, which was a viable option for a lot of survivors, there was the recent decision out of the Supreme Court which eliminated any non-economic recoveries for violations of Title IX. And so that pulled the rug out from under a lot of people in schools, because if you're an 11th grader and you've had gender violence against you or gender-based sexual violence, and you bring a claim against the school that didn't, stop it or didn't intervene or was deliberately indifferent in that situation, you only have economic losses. Well, what does an 11th grader have as an economic loss? They're not paying for the public education. Right. Maybe they've got $2,000 of bills for counseling paid for by the parents, covered by insurance likely. They don't have enough to really get in the game and get an attorney to represent them, unless, of course, they have enough money to pay the attorney on an hourly basis. So it's sort of now turned into, a remedy for rich kids.
I think we've talked a lot about, the financial aspect of this, but the other thing that's coming up in my mind is that there is a lot of mental and emotional bandwidth that is required for this process. And depending on, a variety of things, a victim that might have a physical or mental disability, socioeconomic status. There are so many factors that we have to think about, marginalized communities. There are some people that just don't have the bandwidth to devote to this process that is so demanding and complicated, and frankly, as an outsider, confusing and scary. And so it's not just kind of the financial barriers, but there's an accessibility issue. Otherwise, there are so many people just trying to survive.
Taking time off from work to go to court hearings, continuances. You feel time and time again you're coming to court and nothing's happening. And for a lot of times it's reasons that are opaque to the average person, may be very legitimate for people within the criminal justice system, but it doesn't seem to make a lot of sense and is absolutely mentally taxing. And that's just a little part of it when you're talking about the overall system. And then you have the families too. I can tell you, like, some of the most haunting sounds I have heard have been mothers of children who the perpetrator has just been acquitted. Like the mother from down the hall, like, that will stay with me for my life. And so that is another part that's sort of overlooked in terms of the support that has to, and some victims don't have that support, and that's just as heartbreaking, if not more, when they're showing up to court and the only person that's with them is my victim witness coordinator. So there's so many ways that that bandwidth, that limited bandwidth, or the variability of bandwidth looks and in different types of harm.
You just triggered me on a court experience we had for a 12-year-old boy that was sexually assaulted at camp. And the mother, we didn't have the young boy in the courtroom, and the mother did not know the full extent of what happened to him. And we had put that on video to be shown at court, so he didn't have to come into court. And she was the one sitting at counsel table. And when that video was shown, we probably didn't do a good enough job to prepare her for that. And she stood up instantaneously, started screaming at the top of her lungs, ran out of the courtroom, and was in the hallway screaming. And the jury was seated. And we rushed out to take care of her. And the defense moved for mistrial, that hearing the screaming mother was going to adversely influence the jury. So when we had gotten her under control, that was the first thing that we faced when we came back in court, was a motion for a mistrial. Judge didn't grant it, and then instructed the jury to not pay attention to that, lectured the mother to get herself under control. But yeah, thanks for reminding me of that.
Which reminds me of another issue that I think is important and overlooked. I had a similar case. I asked that the crime victims advocate to not have the parents in when this little boy was here testifying. And the reason was, culturally, I knew, I mean, you have to be aware of a lot of things, including the background of people and their cultures. And I knew that if the parents actually knew and actually heard about what happened, there would be an honor killing of that child. And so we kept him out. The guy was convicted. The family never really understood, and we were very happy of that. And we talked about it afterwards, because at first I got some flack saying, how dare you not let them? I said, it's not that I didn't let them, it's that it's the better choice, because I don't want a homicide to be the next case.
And when we're talking about preparing victims and having real conversations with them too, that's why it's just as important to have those conversations with the family. And I will ask sometimes, how much do you want to know about what happened to your child? And I will have that conversation with them, because after all, that parent still needs to be a support for their child. And I want to make sure that I'm doing everything I can to protect them, to be able to support their child in the process as well. So it's important to have the conversation with all of the people in that room.
And we have it with have it with the child when we're representing the child, because we have to get consent from them as to what we will disclose to their parents, because that's still their agency. So we often have in our agreements that you can talk to us freely about what happened, knowing that you can tell us that this is not going to be conveyed to your parents. And then we have to have an agreement with the parents that saying, we're going to represent you with respect to this, but what you say to us can be confidential and kept from your child, and vice versa. And they have to agree to that, because I don't think we feel as our role as the attorney is to be the one to communicate that necessarily as to what exactly happened. That's going to be that's going to be a lot of decision making in that, as to how the parents find out, who explains it to the parents, and whether or not the child even wants the parent to fully know it. That's their information.
And sometimes some of the even harder conversations are with parents who don't understand the impact that the system will have on their child. They think that it's going to be some version of Take Back the Night. And I have to explain to them that that is not what is going to be happening in court, in the courtroom, or it has the potential to be very, very different from that. And it's not Law and Order SVU. And so when parents are just automatically, oh yeah, my kid will be fine. My kid will be fine to take the stand. Oh, she's brave. She's totally, and I have to tell them, I have to have real conversations with them about what this is going to look like. And that can be really, really hard for the parents to understand, that this might be why we want to talk about strategy for the case going forward. This is something we have to consider when we're talking about how we want to approach charging it, how we want to approach discussing a plea, what we are trying to accomplish with respect to protecting the child, messaging to the child, conversations that, depending on the age of the kid, I will have those conversations straight, if it's straight with the child, 15, 16, if it's 3-year-old, obviously, totally different. But being able to navigate that dynamic is just so important, to be there on the ground and seeing those moving parts and adjusting accordingly.
Counseling.
And it's complex.
Yes.
I mean, because you have to think of like everything that's out there that may be happening, so that they don't get surprised.
Right.
And everybody needs counseling,
Yes,
not just
absolutely.
the child, but the parents. We had in the Nassar case, which I'll say because people watched it, it was public, the dad who didn't believe his daughter, who committed suicide. And, so it's not just the child who's at risk of public shaming, all sorts of other things that could happen. They have to be prepared for it like you prepare them, but also the family has to be prepared to hear it and deal with it and go to counseling and understand it's not their fault. It wasn't that dad's fault. It wasn't the daughter's fault. It was Nasser's fault totally. But the guilt and shame on the parents who say, how did I let this happen to my child? That is also, has to be in the equation, and it's also horrifying to those parents.
It's so much in the equation when it happens involving caring parents, because some of them are so centrally focused on, I should have seen something, I should have done something, there was something I could have controlled, how did I not control that? Now that I've retained a lawyer, I need to control a lot of things. I need to control the way this ends, otherwise I will not feel like I've done anything of meaning to help my child and protect my child.
And explaining that families are groomed too. Parents are groomed, I mean, just as much as the kids in many of these cases. I mean, the Nasser case, are in the room. And that is not the fault of the parents, but they can see that they would take that on themselves. But that is just evidence of the manipulation, the level of manipulation with so many of these perpetrators, because that creates gaslighting in and of itself.
One of the moms who was there, she said to me much later, after the case was closed, I met her, and she said, my daughter, they drove 3.5 hours every time to see Nasser. And she said, I drove her 49 of the 50 times she went. And I put my daughter in the hands of a monster, and she was in the room. How could I have done this? And I explained to her, you didn't know, there was no informed consent. He blocked you. He had a method, plan, scheme designed that was his own. It's no fault of yours. And she said, I will live with this guilt for the rest of my life. And you know, I listened to her for a few hours and we talked, and I think she felt better, but it's clear that it was going to take a lifetime for her to get over the trauma.
Yeah. But I also think that is, we have to underline the fact that people in positions of power like yourself speaking up and plainly stating, this was not your responsibility. I know you feel guilt and I acknowledge that, but this has to go back to the perpetrator is so, so, so powerful. And I mean, coming back to being trauma informed and taking that into conversations, not only with victims, but also with their families, because so many of these families are also traumatized and dealing with their own level of grappling with how did I let this happen, it's like it should be mandatory.
And when you're preparing someone for cross-examination, I don't want there to be surprises if a kid victim going in be cross-examined. But I go over the types of questions that are going to be asked, but I just make it as clear as I possibly that every question I am asking you has nothing to do with whether I believe you, whether the people in this room believe you. This is all about preparing you for what is going to come in court. And I repeat that as much as I can so they internalize that this, at no point, any questions that I ask, anything that I am telling you, I do not want you to take anything as me saying, I don't believe you, because we're going to have real conversations here. But I always want you to take that with you, that, you know, my victim witness, your mom, myself, everyone sitting here believes you.
Yeah. In closing this conversation, it's become so apparent to me through this conversation too that each of you feels a lot of responsibility on this issue. You each kind of have your personal connection to it, but you each feel like you have a role to play in this issue, and you have a very profound role in the lives of these people. And, you know, I just have to imagine that you are a presence in their lives forever, which is a profound gift and also a profound responsibility. In closing, I would like for each of you to just speak a little bit about if you had to sort of choose one message for these viewers who might be somewhat new to this issue, but might be, unfortunately, extremely familiar with this issue. If you could leave them with one thing from your professional experience, but also your personal connection with this issue, what would it be? Maybe, Elysse, I'll start with you.
the first message is always going to be, it's never your fault.
Yeah.
It is never, ever, ever your fault. And no matter what anyone says, any questions they ask, it was never your fault. And that it should be, you should have the power to determine your life going forward. From this time forward, I'm going to make sure I do everything I can to give you the agency to make choices. This should not define you, and I'm going to do everything I can to help it not define you. And I have every bit of belief in you as a survivor that you are going to go on and do great things because I believe in you. And I always, always try to leave people with that message, kids with that message, because everything I can do to empower them through a system that can be demoralizing and disempowering, I want to do the opposite in every facet of the way I am interacting with them. As much as I can empower people, I take that responsibility incredibly seriously, and it's a privilege.
I agree with all of that. And I want to add, if you see something, report it, trust your gut, have the tough conversations with your children as early as when they learn to say mom and dad. They should learn body parts and that they have the right to say no and the right to be informed if someone's going to touch them in any way, and have these really important conversations. And if you're unsure, just report it. If you don't report it, it will continue. If you do report it and you get it wrong, there is no consequence. If you get it right, you're saving a life.
Thank you.
I agree with everything they've said, but like putting, the issue is so complex,
Yeah.
and there are so many circumstances involved in the world of sexual assault and violence against women that I don't know that I have a singular message. It's so hard. I think if they're going to enter the civil system, do your level best to find an advocate that has experience in this area and truly cares and isn't doing this as just part of some general auto trucking practice, because they may not be trauma informed, or it may be the first time they've done it, or it may be something that isn't, in their bailiwick that gives you what you deserve at this point in time in the agency that you should be able to recover. The agency you should recover for yourself. It's not focused on necessarily the recovery you may get from the lawsuits. But it's another one of those very important choices. And, were I to say something to women about college, I would say you shouldn't step in a fraternity house without your eyes wide open. I would say that you shouldn't go into a fraternity house without a friend and a plan to stay together. And if you can't find your friend, you should go find your friend. I would say you should not drink from an open container in a fraternity house. They're dangerous. And I've seen that time and again. And I've seen that they're mismanaged. And I see that they don't do anything about the management issue. They just insure against the risk. So that's what I would say to women going to college.
Yeah.
I just want to add, if you report it to your local police and they don't do anything, go to the Attorney General, find an agency, go to the state police. Not all police departments are created the same. Not all prosecutors are created the same. But you need to find someone who will listen. And there are a number of different agencies. Same with lawyers. You need to find a lawyer like Doug, because some lawyers are looking at the case as the bottom line. I'm going to get this much, my percentage, and they're going to turn it into a meat market. Doug cares. He knows. He has a track record that shows that. He's compassionate. He's informed. His staff is the same way. And so you interview the lawyer. You also have control over what lawyer do you choose, what firm. And again, trust your gut. Is that the right fit for me? It's okay to test out 10 different lawyers if you need to, and go with the one that you're comfortable with, who will do the work because it's the right thing to do, not because of the recovery.
And on that point, and this isn't pushing me by any stretch of the imagination, in the legal world, if you're thinking it in a way similar to the medical profession, if you're going to go in and you're going to get like brain surgery, you're not going to your general practitioner.
Right.
I think you're going to a physician and you're saying, well, could you give me an idea of how many times you've engaged in brain surgery and what your success rate is? That would just be standard in that profession. But so many times people are going to the legal profession and they're thinking, well, this lawyer's got a billboard that says $75 million. This lawyer has all sorts of numbers on their websites and things like that. And what they may not know is that this is perhaps the first and only or the second case involving sexual violence that they've ever worked on. And in the legal profession, there's not a sentiment that says you have an obligation as an attorney to say, well, wait a minute, this is really going to be my first time. And so what's unknown to the public on some listservs that I'm a member of, I won't mention them all, but a lawyer will be sending around a note saying, hey, does somebody have an example of a complaint I can file in a case involving a sexual assault at a school? And that's indicating they've never done it before.
Yeah, right.
And so I've responded in many of those circumstances and said, well, does the client know that you're making this up as you go along?
Yeah.
And then other lawyers will respond and say, well, everybody does something for the first time, and so this person is entitled to get experience doing it for the first time. And you wouldn't accept that in the medical profession.
For brain surgery.
For brain surgery.
Go be an associate.
For something that's really important.
Right.
I
Life
mean,
or death, really.
Well, if you're thinking about sexual violence, that is most likely the biggest, baddest thing that's happened in somebody's life. I would compare it to needing brain surgery. You wouldn't accept less in the medical profession. And so it's not pointing to me, it's because there's a lot of people out there that do this type of work. But that's the type of question that we tell people to ask. Ask them, how many times have you done this?
Yeah.
And what has been your success rate? What have you gotten for survivors?
Yeah.
And invariably, you'll hear people talk about trucking cases.
Yeah. And under the Crime Victims' Rights Act, victims have a right to know every single thing that's happening. So they can call law enforcement, they can call a prosecutor's office, they should be receiving notices. If they're not receiving notices, something is wrong. Call. It's their right to call, to ask, and figure out what the problem is. So they do have rights, they just have to be assertive, and if they don't feel the strength to do that, ask a lawyer, ask a friend to go with them. It is their right to know.
Yeah. Just that little bit of it's that first moment in this process of having control, taking control, which can be really empowering for people.
And having a support person with you.
Yeah.
I mean, it makes a huge difference.
Yeah. I don't think it is overplaying this conversation to say that this conversation actually has impacted my life. I just am so grateful to the three of you to get to share this table with you, to get to share this conversation with you. I just can't imagine the impact that the three of you are having on not just this space, but on the families and the individuals who have gone through something absolutely terrible. Thank you for the work that you all do. Thank you for sharing this conversation with me today.
Thanks for doing the program.
Yeah, thanks
I think
for
people
asking the questions.
Yeah,
Thanks
people
for
should
pushing
know
it
these
forward.
things.
Yeah.
And giving the platform for more people to understand and hopefully take it into their communities too.
And thanks for We Ride Together.
Yes. Cheers. Cheers to that.